So welcome to the penultimate lecture in this year's Edmund J. Safra Center for Ethics lecture series. My name is Lawrence Lessig, the director of the center, and a professor here at the law school. And I'm very happy to welcome back to Cambridge tonight Joshua Cohen. In 2 weeks, we will have the final lecture for the year, originally intended as the Republican response to Congressman Jim Cooper's lecture about how to fix Congress. But as is often the case with original intent, that intent has been complicated a bit by the fact that the person who will deliver that lecture, former Governor Buddy Roemer, is now a candidate for the Republican nomination for president. But Governor Roemer has promised me to put aside that campaign to talk about this institution that he came to know first with Jim Cooper. Indeed, Jim Cooper's brother was his first campaign manager, and so I look forward to welcoming many of you back for that evening for our final event. But tonight we're extremely happy to have someone who is not a candidate for president, I take it, Joshua. Professor Cohen is the Martha Sutton Weeks Professor of Ethics and Society at Stanford University. He's a professor in the law school as well. He is also the director of the program on global justice at the Freeman Spogli Institute. Josh is a political theorist who was trained in philosophy here at Harvard under the guidance of John Rawls before moving to Stanford in both the political science and the law wings of that university. He was a professor of political science at MIT. His writings span a wide range of topics from human rights to democratic theory to the work of Rousseau. But the bit about this extraordinary scholar that has most impressed me, and of course many others besides me, is a certain ethic that he carries with his work. His latest book, The Arc of the Moral Universe, is a good example of this ethic, and I think you'll see that the lecture he's delivering this evening is an example of this ethic as well. In these works, he feels himself obligated to link a very practical, tangible question of practical politics to a rich and insightful understanding of history and political theory. The first third of his essays in The Arc of the Moral Universe tie democratic theory to history. Second third ties it to leading philosophers such as Chomsky and Oken and Rawls and Locke, among others. And the final third tries to tie this democratic theory to issues of global justice with the extraordinary idea, to some at least, that there might be such a thing as global public reason, that it would include America in that conversation. It makes it a little bit hard to imagine, but so in my view, this is a very Tobin-like commitment to keeping our work relevant, admirable discipline to work across fields of theory and history while working to render the insights useful for urgent global needs. Josh's work, sharing the responsibility of the editor-in-chief of the Boston Review, is just another example of this ethic. The Review has become a focal point, as you all know, for intense literary and political debate. Frank Michelman described it as sustenance for intelligent life on Earth, operating, as Kenneth Galbraith put it, at a level of literacy and responsibility, which is all too rare in our time. But such follows, I suggest, from the nature, at least, of the editor whose work I know best, and so I'm very, very happy and honored to welcome him to the Center of Ethics and to thank him for his contribution that he's about to share with you. Josh.
Thanks very much, Larry, for those nice words. Does anybody need to sit down? I mean, anybody who isn't sitting down. All right, there's another chair here. That's what I was trying to say. Okay, so it's very nice to, hey, yeah, sure, yeah. It's very nice to be back here. Lots of, some might say old friends, I say friends of long standing. So my title is a question. The question is, I'm not got to get the intonation right, Citizens United versus Democracy. And it begins with 3 quotations. Bear these in mind. Not so much in mind that it distracts you from what I'm saying, but bear them in mind as I go through. The first quotation says, Everyone is a philosopher, though in his own way and unconsciously. That's Gramsci's Prison Notebooks. The second quotation says, "In justice as fairness, there are no philosophical experts, heaven forbid." That's John Rawls responding to Habermas. And the third quotation says, "Democracy in America was the spectacle," this was Democracy in America from Jefferson to Lincoln, "was the spectacle of Americans arguing over democracy." That's from Sean Wilentz' book, The Rise of American Democracy. So, the title, as I said, is a question, Citizens United versus Democracy, and my answer, at once laconic, oracular, and evasive, is yes and no, but yes. The rest of the talk will explain that answer. So, we all know the basics or have heard the basics and pretend to know them. Let me start with a brief review, though, of the basics, adding just soupçon of tendentious granularity. So in the 1990s, and with accumulating momentum through the decade, Congress debated changes in our system of electoral finance. The animating concerns for reformers ranged widely: a rapidly growing cost of elections and associated demands on the time of elected officials, a political process that, in part because of those growing costs, struck many as unacceptably dominated by money and special interests, worries that public skepticism about democratic politics was sprouting from this unhappy soil, growing economic and political polarization, arguably fueled by changing terms of election finance, and an apparent circumvention of the purpose of existing campaign finance rules through the use of soft money and issue advertising. To be sure, these concerns were not universally shared, either in Congress or in the wider public. Moreover, these hesitations contained much insight. Why, in view of the importance of elections, shouldn't they cost a lot? If legislators were spending time raising money, maybe they were talking to people they should be talking to. And how could we trust incumbents to resist anti-competitive reforms? Those reasonable questions, and many others, were very much part of the public debate. Still, public dissatisfaction was palpable, and Congress devoted considerable time to the issue. After 6 focused years of hearings, debate, and legislative compromise, all subject to the pressures of public opinion and organized reformers, and all conducted in the shadow of the Constitution, Congress enacted some reforms, popularly known as McCain-Feingold, less popularly as the Bipartisan Campaign Reform Act, or BICRA. The reform debate was conducted in the Constitution's shadow because a legal challenge to the leading reform proposals was assumed from the outset. So proponents of reform drafted their proposals in light of this confident expectation. As the debate drew to a close in March 2002, then Senator Russ Feingold said on the Senate floor, "I assure my colleagues that we have had one eye on the eventual court challenge ever since we started this process. This bill has been carefully crafted to take account of the Supreme Court's decisions in this area. Can I guarantee that every provision will survive a court challenge? Of course not. But I can tell you that we have done our very best to design these reforms in a constitutional manner." Others, of course, took a different view. Senator Graham, Phil Graham, for example, described the bill as blatantly unconstitutional. Indeed, he said, quoting from that debate that same day, "as blatantly unconstitutional as any bill which has ever been written, any bill which has ever been adopted by the Congress of the United States." And Senator Graham looked forward with hope to the day that the court would use, quote, "the flaming letter of the Constitution," as opposed to its animating spirit, I guess, the flaming letter of the Constitution to strike down this bill. So the rhetorical tides were running high. But constitutional concerns infused the discussion. Indeed, the term constitutional and its cognates were used 160 times in the debate on March 20th, 2002, comparable to the frequency of the use of the term democracy and its cognates. Now, the result was, of course, no one's first best, but BICRA was serious and seriously did four things. First, it instructed political parties to retire from the soft money or non-federal funds business, the business of trafficking in funds not regulated by federal election law, understood not to be for campaigning but for party building and get out the vote activities, non-federal funds which had grown to 42% of party money in 2000. It increased the ceiling on individual contributions to candidates and parties, in part to ensure sufficient resources. It established new disclosure and reporting requirements, and it prohibited corporations and unions from using their general treasury funds for electioneering communications, which it defined as, quote, any broadcast, cable, or satellite communication that refers to a clearly identified candidate for federal office and is made within 30 days of a primary or 60 days of a general election. Now, focusing on these controversial electioneering communication provisions, federal election law had long prohibited corporations and unions, corporations longer than unions, but had long prohibited both, from making independent expenditures as well as contributions from their general treasuries. But expenditure restrictions had been narrowly construed as a ban on express advocacy of a candidate's election, which left considerable room for all but express advocacy, for issue ads, interpretable as contributions to the kind of open-ended discussion of public issues that the First Amendment is meant to protect. So, an ambiguity insertion industry had emerged to write issue ads that permitted corporations and unions to play the electoral role that Congress had arguably instructed them not to play. According to a substantial legislative and judicial record accumulated in connection with BICRA and the challenge to it, electioneering communications by corporations and unions were serving as ways to evade the evident purpose of previous regulations, the purpose of keeping corporations and unions from playing a direct electoral role. In 2003, in the case of McConnell versus FEC, the court upheld the soft money regulations and the regulations of electioneering speech. Then, last year, in Citizens United, the court overturned the rules on corporate and union electioneering communication. Ted Olson, who argued Citizens United, recently broke all existing records for self-congratulation when he called it maybe, this is a quote, maybe the most important case in history. Maybe. I think he wanted to leave room so that next time he could say this was the most important case in history without, anyway. Okay, so the court announced that electioneering communications could not be regulated, nor could uncoordinated express advocacy of a candidate's election. Regulating such expenditures was said to impose a, quote, ban, unquote, on core political speech. So companies and unions could simply write the check to cover expenditures instead of funding expenditures, as they had previously been able to do, by enlisting contributions by individuals to segregated funds, that is, funds administered and financed separately from the corporate or union treasury. For the Citizens United majority, the result was a more or less mechanically jurisprudential application of the Buckley framework, the legacy of Buckley and Vallejo, 1976, the dominant case in this field, with its fundamental distinction between contributions and expenditures and its focus on the singular evils of quid pro quo corruption. Set in contrast with contributions to candidates, expenditures have two things going for them, according to the Buckley framework. First, they represent a richer expression of the speaker's views than a simple contribution, which simply shows support without conveying a more discriminating message. Or so Buckley said, though I confess I am with Justice Thomas in finding the point a little bit elusive. Second, expenditures don't threaten contribution, not at any rate the money for votes corruption that represents the sole basis for restricting speech in this setting, as distinct from what Justice Scalia once described as the new corruption of unfair influence that had emerged as a rationale in the 1990 case of Austin versus Michigan Chamber of Commerce, was subsequently reaffirmed several times, including in McConnell 2003, and is now dropped. So that's the background. I come now to section 2, which is called Lochner-itis, ? So writing in the New York Review, Ronald Dworkin described Citizens United as, quote, the decision that threatens democracy. Others have been comparably hostile, and one reason for the hostility, forcefully stated by Larry Lessig in a piece that he did in Boston Review last year, is that Citizens United shows clear symptoms of Lochner-itis. In 1905, the Supreme Court, in the decision of Lochner versus New York, resided greater confidence in its own factual judgments about the effect of long working hours on health than in the factual judgments animating Section 1 of the 1895 Bake Shop Act. Judgments of the New York State Legislature, which unanimously passed the legislation twice, judgments of its Public Health Committee, and judgments of the State Health Commissioner Cyrus Edson, who said, quote, the provision limiting the hours of work time of the men is especially good from a sanitary standpoint. There is unmistakable evidence that these men are overworked and that in consequence of this they are sickly and unfit to handle an article of food. Similarly, Larry Lessig finds Lochner-itis in the unwillingness to defer in Citizens United, the unwillingness to defer to the empirical findings that helped to shape BICRA. An unwillingness to defer that's perhaps nowhere more in evidence than in Justice Kennedy's strikingly confident assertion, an assertion backed by non sequitur, that, quote, the appearance of influence or access will not cause the electorate to lose faith in our democracy. Well, you can see the confidence in the assertion. Let me pause for a moment to explain what I mean when I say that it's backed by non sequitur. Here's the offending argument, quoting, by definition, an independent expenditure is political speech presented to the electorate that is not coordinated with a candidate. So far, so good. I mean, that's a fair statement of the definition. Now, the fact that a corporation or any other speaker is willing to spend money to try to persuade voters presupposes that the people have the ultimate influence over elected officials. This, he says, is inconsistent with any suggestion that the electorate will refuse to take part in democratic governance because of additional political speech made by a corporation or any other speaker. Now, this isn't simply any old non sequitur. What this one does is to transform a straightforwardly empirical thesis, a contestable empirical hypothesis about voter responsiveness to certain appearances, on which judges have no particular insight, into a conceptual truth on which judges are, at any rate, no worse than the rest of us. Let me illustrate the point with an example. There was a book written in 1997 by my current colleague, Shanto Yangar, and my former colleague, now your colleague, some of you here, Steve Ansalabaher, who wrote a book on the effects of negative advertising. The subtitle of the book was How Political Advertisements Shrink and Polarize the Electorate. And the thesis of the book was that voters are put off by negative advertising, and because they're put off, they stay away. They vote less. Some people have argued that that's the point of negative advertising. I leave that judgment to others, not to other judges, but to others who know something about the subject. What seems clear is that this spending, the negative spending, presupposes that the people have ultimate influence over elected officials. This spending is designed to shape that influence, and it may have well have the effect, this is the Ansala-Beher-Iyengar hypothesis, may well have the effect of leading some of the electorate to refuse to take part in democratic governance. The worst that you can say is that their view is wrong, and some people have argued that it is wrong. The so-called inconsistency eludes me. However, while, that's not a good way to start a sentence, no. This is the problem. You know, you edit a magazine and, Anyway, while I agree with Larry, but while I agree with Larry Lessig that Citizens United shows symptoms of Lochner-itis, I think his case for that conclusion has limited force. So what made Lochner an instance of Lochnerism was not simply deficient deference to the factual judgments of political branches. The problem was the prior insistence on a compelling case for regulating labor markets, an insistence that reflected the prior elevation of market liberties to a privileged position and, relatedly, identified conflated concerns about fair bargaining with a paternalistic regard for workers as wards of the state. Now, Larry, in effect, acknowledges this point. He says, to be clear, I'm not saying that the court should treat First Amendment questions the way it treats questions about the regulation of contracts. I, along with every justice on the court, believe that free speech deserves a much more vigorous defense against improper legislation than the liberty of contract. But if that's true, then it's appropriate to ask whether the lack of factual deference in Citizens United is really comparable to the lack of factual deference in Lochner. Why wasn't the court majority in Citizens United simply providing the more vigorous defense of free speech that was conceded by Larry, to be appropriate? So I think, Section 3, disagreements about democracy, I think that the trouble with Citizens United lies elsewhere, not in a want of deference to legislative fact-finding, but in the imposition of a contested philosophical position about democracy, as the Lochner court imposed a contested philosophical position about economic liberty. To explain the setting, I want to take a quick step back and offer a crisp illustration of the kind of thing that I have in mind. So, Justice Scalia has published a book called A Matter of Interpretation. Justice Breyer has published a book that originated as Tanner Lectures at Harvard, a book called Act of Liberty. Now, observed from 30,000 feet, the central thesis in both books is the same. For both, the Constitution is, in some fundamental way, a design of democracy. For both, judges ought therefore to be more attentive to democratic concerns in the work of both statutory and constitutional interpretation. So both endorse what you might call the democratic inference, the inference that goes like this: because the Constitution is a design of democracy, interpret it as follows. Well, the 30,000-foot similarity is relevant, but arguably as relevant, maybe more relevant, is the disagreement revealed by a higher resolution observation, say from 29,999 feet. So Scalia's democratic inference ends in textualism. He says it is simply not compatible with democratic theory that laws mean whatever they ought to mean and that unelected judges decide what that is. Breyer's conclusions are about purposive interpretation and about how to see free expression, equal protection, federalism, and administrative law all through a democratic prism. So, same premise, 30,000 feet, conflicting conclusions. What's up? There are three hypotheses about the answer. I'm looking for my water, yeah. That's great, thank you. This one was around too, but I think somebody else got started on it before me, so I'm going to stay away from that one. Okay, so three hypotheses about the answer. Maybe, first, Scalia and Breyer come to different conclusions because of empirically different driven disagreements. I'm sure that's true. Maybe, second, they both think that there are other constitutional values than democracy. Of course they think that, and their differences probably come in part from the interpretation and weight they attach to those other values, say rule of law values. And third, maybe, and here I mean maybe in the technical sense of undoubtedly, maybe they understand the democracy enacted by the Constitution differently. Both accept the abstract proposition that the Constitution enacts a scheme of democracy, but they interpret that proposition very differently in Breyer's case with reference to ideas of a, quote, well-functioning participatory democracy, with a conversation among ordinary citizens animated by a sense of, quote, fraternity, unquote. In Scalia's case, with no evident attachment to those arguably hyperfluid values, and those differences of political philosophy, shape their different conclusions. Now, I mention these conflicting interpretations of a shared premise not as an entry point into exploring their views. I simply want to illustrate a familiar observation. The observation that competing theories of democracy are part of constitutional and political argument, not simply the topic in a political philosophical cloister. Building on the idea that such competing theories draw interpretation in different directions, I propose to sketch two fundamentally different conceptions. One, I'll call it civic equality, makes Citizens United deeply troubling for popular self-government. The other, I'll call it limited government minimalism, suggests that Citizens United was required to protect popular self-government. I'll then ask what we should think about the court's decision to settle the political philosophical argument by overturning important parts of BICRA. Two final prefatory points about the presentation of the conceptions. First, I want to be clear, there are other conceptions of democracy. My aim is to illustrate a point, not to exhaust possibilities, much less audiences. Second, I find the civic equality conception more compelling, and we'll be giving a little more time to it, in part to distinguish it from its popular caricature. But I want to be clear that limited government minimalism has distinguished intellectual pedigree, considerable popular resonance, and is, on any account of reasonableness that I would want to be associated with, a reasonable conception of democracy. So the civic equality conception, this is the next section of the paper, the civic equality conception, Section 4, comprises four main ideas. The first is that citizens are assumed normally to have conceptions of justice and the common good that shape their political judgments, as well as interests and an assumed competence to understand and protect those interests. These ideas are important in interpreting the notion of citizens as free and politically autonomous. Second, that authoritative collective decision-making among citizens thus conceived has a deliberative aspect, that in a well-functioning democracy, decisions are arrived at through an open and dispersed process of public communication in which individuals can acquire information, express judgments, guided by ideas of justice and the common good, and argue with others about law and policy in light of their conflicting views about justice and the common good. Moreover, third, that citizens are to engage in that process of communication and argument as equals, with equal standing in the processes of collective decision-making. And fourth, that ultimate authority lies in the people, understood as a community of free citizens engaged in public discussion as equals. Now, to crystallize the implications of this view, what I want to do is to sketch a principle of political equality rooted in the civic equality view, a principle that brings these four components of civic equality, its ideas of political autonomy, deliberativeness, equality, and popular accountability, to bear on arrangements of collective decision-making. So according to the principle of political equality, institutions for making binding collective decisions are to ensure three conditions are met. First, that there be equal rights of participation, including rights of voting, association, and office holding, as well as rights of political expression, with a strong presumption against restrictions on the content and viewpoint of expression. Secondly, a strong presumption in favor of equally weighted votes. And third, equal opportunities for political influence. This last requirement, what Rawls calls the fair value of political liberty, condemns inequalities and opportunities for holding office and influencing political decisions. Now, conflicts may emerge between and among the norms comprised by the principle of political equality. So when conflicts emerge, we can't say a priori which value is to give way. In particular, if we accept this three-part principle, then we allow that we may need to regulate speech to avoid certain kinds of inequalities in opportunities for political influence, though with a strong presumption against the content and viewpoint regulation condemned by the first element. Now, the third requirement, the equal opportunity requirement, is modeled on a familiar equal opportunity norm, which says that one person ought not to have greater chances than another to attain a desirable position because of some quality that is irrelevant to performance in the position. So for the sake of discussion here, I'll say that irrelevant to performance in the position means, following roles, that people who are equally motivated and equally able ought to have equal chances to attain the position. When this conception of equal opportunity is applied to the political system, the relevant position is active citizen in the formal arrangements of collective decision-making. The requirement then is that people who are equally motivated and equally able to play this role by influencing binding collective decisions ought to have equal chances to exercise such influence. Now, I don't propose here to defend this principle, but I want to make three clarifying comments about the principle of equal opportunity for political influence. One clarifying comment about equal, one clarifying comment about opportunity, and one clarifying comment about political. I won't clarify for or influence. So, first, political equality requires equal opportunity for effective political influence rather than equality of effective influence itself. Some citizens may be more influential because, for example, they care more about politics. Differences of influence that trace to such differences in values and choices are unobjectionable. Similarly, if a person is more influential because her views are widely shared or judgment widely trusted, the differences of influence trace to the distribution of political values and commitments in the population, a distribution to which the democracy of civic equality should be responsive. The requirement of equal opportunity for effective influence condemns certain kinds of effective exclusion or dilution, but it does not support charges of objectionable exclusion or dilution merely because I'm unwilling to make reasonable efforts to persuade others, or because others think my views are misguided or ridiculous or my judgment suspect. What about inequalities due to differences in persuasiveness or, for example, differences in physical attractiveness? Regulation here would defeat the point of political discussion among equals that is also essential to civic equality. After all, differences in persuasiveness are not irrelevant to performance in the position. Similarly, we could try to control the power that flows from being attractive, such as it is, but only by measures that would keep people from appearing before one another. You know, you could only have audio, no video. And those regulations would, on their face, be damaging to political judgment. So the reasons for emphasizing opportunity are pretty straightforward. It's unreasonable to demand influence irrespective of one's own actions or of the considered convictions of others. Unreasonable because a compelling interpretation of the idea of political equality as the civic equality of politically autonomous persons engaged in argument aimed at arriving at collective decisions must ensure a place for individual responsibility. Members of a democratic society are responsible for their political judgments and conduct. Once we accept such responsibility, then we accept, too, that a regime of equal opportunity for effective influence is almost certain to be associated with inequalities of actual influence. The permissibility of those inequalities is not an accommodation to imperfect information or some regrettable facts about uneven interest in public engagement. It is an unavoidable consequence of our freedom and our differences, not at all an object of regret. Second, the principle requires equal opportunity for political influence, not simply some threshold of sufficient or adequate opportunity. Now, adequacy may seem reasonable because it arguably makes sense for the distribution of economic resources. Although the equality of citizens as moral persons arguably provides a basis for concerns to mitigate socioeconomic inequalities, that pressure is limited by the mutual benefits that can flow from inequalities. A parallel case can be constructed, so it may seem, for inequalities of political opportunity. Although the equality of citizens as moral persons imposes some pressure to reduce inequalities of political opportunity, that pressure is limited, it might be argued, by the mutual benefits that can flow from inequalities of opportunity. But this parallel is limited. One reason that resource inequalities may not be so troubling in a political community of equals is precisely that our equality is already affirmed through our equal standing as citizens in the system of authoritative collective decision-making. But if inequalities of opportunity extend to authoritative collective decision-making itself, then the public basis of mutual respect is less secure. Equal political rights with equally weighted votes go some distance to ensuring this equal standing. But that may be because the equally weighted votes are themselves a form of equal opportunities for influence. Now, third, the principle requires, so it was equal opportunity for political influence, equal opportunity for political influence. Why the political? So consider three interpretations of the idea of political equality. First, equal opportunity for electoral influence, which condemns inequalities to hold office or influence the outcome of elections, but is confined to the electoral setting. Equal opportunity for political influence extends beyond equal opportunity for electoral influence by condemning inequalities and chances to influence decisions made by formal political institutions. So it condemns conditions in which citizens have equal chances to influence the outcome of elections, but unequal chances to form or join groups that influence the outcome of legislative decisions. Equal opportunity for public influence, or the electoral political public influence, adds a condition of equal opportunities to influence the formation of public opinion in the wider informal public sphere. Now, the principle of political equality, as I've stated, it requires equal opportunity for political influence and is thus more stringent than the norm of equal opportunity for electoral influence. But it doesn't go as far as equal opportunity for public influence, and why not? There are a couple of reasons for this, but I want to mention just one, and that is that I think the content of the requirement of equal opportunity for public influence is very obscure. The informal process of opinion formation, unlike political influence, is not at all well-defined or well-bounded. It extends throughout life, spreads through all its spheres, and the processes involved are not at all well understood. So it's not even clear what the requirement demands. I don't mean simply that it's unclear what should be done to equalize chances for public influence. I mean that the goal itself is obscure, and in politics, obscure goals are an invitation to abuse. To be sure, effective chances to persuade others and discuss cultural and political issues are important, but those chances are ensured by the expressive and associative liberties that fall under the first part of the principle of political equality and by assuring some kind of fair distribution of resources. So democracy as civic equality represents citizens as inter alia participants and speakers with ideas of justice and the common good who may aim to reshape both the terms of political debate and its results. This view may seem to depend on some kind of Aristotelian picture about the good of political participation or a Rousseauian theory about personal autonomy and self-legislation. But the idea that citizens have a fundamental interest in bringing their conceptions of justice to bear on the conduct of political life, to have what Martin Luther King called the right to protest for right, that has wider reach. Different moral outlooks support the idea that there are strong reasons for exercising responsible judgment about the proper directions of collective life and aiming to correct those directions, particularly when they're unjust. And those reasons are even more compelling when authoritative collective decisions are made in the name of those over whom they are enforced. The weight of these reasons is expressed in the equal rights of political speech, association, and participation of the first component of the principle of political equality, but they also provide a case for opportunities for effective influence on the political environment. Moreover, because claims for effective influence reflect the standing of citizens as equals, those claims are for an equal chance to influence. A failure to provide such is a failure to acknowledge that equal standing. At the same time, civic equality is anti-paternalist. Individuals are responsible for finding signals in the ambient political noise and for judging how far they wish to go in taking on the role of participant and speaker. For civic equality, free political speech without content or viewpoint restrictions is essential, as is the opportunity to influence versus influence distinction. Now, what bearing does any of this civic equality conception, have on BICRA? As I said earlier, BICRA was no one's first best. So it was not the first best of civic equality Democrats, who generally preferred clean money public financing, or low limits on contributions, or vouchers. But politics is not philosophy, life isn't first bests, and some elements in BICRA make good sense for civic equality Democrats. Consider first the soft money provisions. Why worry about soft money? One concern is that soft money was corrupting democracy. Corrupting democracy not through the quid pro quo between donor and candidate that has long been acknowledged as a legitimate purpose in regulating campaign finance. Instead, soft money was a concern because of the promise to buy access, thus to buy greater chances for influence by providing parties with large resources outside federal limitations. We can identify that purpose, and I think we should identify that purpose with Larry on this, as avoiding corruption. But then the corruption is a violation of the norms of democracy, an undermining of a fair political process, not an exchange of money for favors. To be sure, part of the case for limiting soft money contributions to parties was that parties are closely connected to candidates, teams of candidates, some people think. So support for parties can induce the same favors from officials that a direct candidate contribution might induce. But when the court took up the soft money provisions in McConnell in 2003, the majority focused not so much or so exclusively on quid pro quo exchanges, but on the purchase of access, the use of soft money contributions to, as they said, by preferential access to federal office holders, and efforts to induce those contributions through peddling and sale of access. The dissent understood this, thus sharply criticized this more capacious conception of corruption as unequal access. But access is one kind of opportunity for influence, so civic equality sees democracy's reason in BICRA's soft money ban. What about regulating corporate spending, even if the spending is independent, that is, by definition, not coordinated with a candidate? There are at least 5 reasons for regulation. First, preventing companies from buying favors. Second, keeping them from buying special access that might give them sway over votes. Third, keeping them from exercising large influence on the conduct of elections. Moreover, fourth, they have focused interest, and spending must be guided by a fiduciary obligation to advance those interests, not by a conception of justice or by considerations about the merits of policy. Of course, individuals sometimes, maybe often, act on their interests, but it's not part of their fiduciary obligation to themselves not to act on a conception of justice or the common good. And finally, fifth, perceptions of excess influence might diminish faith in democracy, the concern that Kennedy dismissed and disparaged. These 5 concerns fit well with ideas about equal opportunity and deliberativeness that we find in the civic equality theory. But there's trouble here. After all, comparable concerns about undue influence might be raised about individuals with accumulated resources. Moreover, most of the many millions of corporations in this country don't have large resources. I work for 3. One of them has a $500,000 budget, one of them has a $16 billion endowment, and another one is sitting on $60 billion in cash reserves. So there's a spectrum. So civic equality needs some resources for singling out corporations and unions, that is, monies from their general treasuries, for special treatment. And there are several such reasons. First, it's commonly observed, correctly, that corporations and unions provide information, and that information may be valuable to political discussion. thus to the informed exercise of authority by citizens. But that information might be provided in any case by individuals themselves or by individual contributions to segregated funds, separate from the corporate treasury. To be sure, raising money for and administering segregated funds are burdens, but disclosure requirements are also burdens, but acceptable burdens in view of their contribution to the exercise of informed judgment. In addition, organizations don't have interest in expressing a view on the merits of the issue. They are not, as I said earlier, deliberators. They engage, as the dissent says, they engage the political process in instrumental terms. They do that as a matter of obligation, as a matter of for companies, as a matter of fiduciary responsibility. But civic equality prizes free deliberation among equals, citizens bringing their views of justice and the common good, as well as their interest to bear on law and policy. This is arguably what lies behind the observation in the dissent in Citizens United that corporations have no consciences, no beliefs, no feelings, no thoughts, no desires. Undeniably true, and for civic equality, indisputably relevant. As Justice White asserted in his dissent in the Bellotti case in 1978, corporate expenditures designed to further political causes lack the connection with individual self-expression, which is one of the principal justifications for the constitutional protection of speech provided by the First Amendment. Moreover, corporations and unions are not themselves members of the people, the supreme authority. So there is no subversion of the relation of sovereign and subject that we have when of the kind that we have when the speech of a citizen is restricted. To be sure, this observation generalizes. Neither MoveOn.org nor American Crossroads is a member of the people, the supreme authority. Still, it seems fair to say, not only fair to say, hard to deny, that their relationship to their members and donors is different from the relationship of, in particular, corporations to their shareholders. So, for civic equality, then, concerns about opportunities for influence provide reasons for regulating, not from some alleged paternalistic concern about misleading messages, but to forestall democracy's corruption. And for the civic egalitarian, the burdens imposed by such regulations are less troubling than comparable burdens on individuals. Thus, the yes in my laconic, telegraphic, oracular, evasive opening answer. That's the yes part. Okay, Section 5, limited government minimalism. So let's now consider an alternative view of democracy that might provide a compelling rationale for rejecting BICRA. Now, Dworkin has argued in a few places that, Ronald Dworkin has argued in a few places that Buckley and its spawn are founded on a majoritarian conception of democracy, on which legitimate law derives its legitimacy from the informed preference of a majority. The First Amendment's democratic purpose, then, is to ensure majoritarianism's favored free flow of information. Now, the idea that the views of opponents, his opponents, in this case mine too, the idea that their views are all about majoritarianism has, for a political theorist, the attraction of dialectical convenience. You bring your criticisms of majoritarianism off the shelf, and then you go out for dinner and your day is done. But I'm unpersuaded that that's what's at issue. More plausibly, I think the hostility to regulations that restrict the flow of information comes from a view of democracy that I'll call limited government minimalism, a conception that comprises 4 elements. So limited government minimalism begins in a self-styled political realism, and I borrow this term from Bernard Williams. Political realism sees competition, particularly, not exclusively, but particularly competition between and among elites to control power as a permanent and fundamental fact of political life. Democracy doesn't transcend that political fact of political competition, particularly elite competition, but subjects it to a distinctive and arguably attractive method of resolution, a peaceful and periodic competition for votes. This view, which arguably traces to Max Weber, is commonly associated with Joseph Schumpeter's critique of the classical conception of democracy and was recently restated by Judge Posner this way. Judge Posner says, "It sees politics as a competition among self-interested politicians constituting a ruling class for the support of the people, also assumed to be self-interested. Democracy is ruled by officials who are, however, chosen by the people, and he might have added, fired for not performing well. Now, while Posner's description emphasizes self-interest, the core of the political realist idea is the emphasis on the competitive aspect of politics. Second feature of limited government minimalism is that a central purpose of subjecting elite competition to electoral resolution is that gives a more secure protection of personal liberty, of Constant's modern liberties in particular. Here, liberty is understood as non-interference with choices, not the self-legislation of politically autonomous citizens. The purpose of elections is not to produce some sort of notional match of policy to majority preference or to a compelling social welfare function. Instead, by subjecting control of state power, an especially dangerous form of power because it is a monopoly, subjecting it to the discipline of competitive elections, we do something to check its improper exercise. In William Riker's formulation, the defense of liberty lies in the discipline of elections. Third, limited government minimalism is infused with a mistrust of political power, which is understood by turns as ineffective or a source of undesirable, if unintended, consequences, or as dangerous in its effects and self-masking in its intent. A mistrust owing to, as I just mentioned, particularly the monopoly quality of political power. To illustrate the concern, consider BICRA. Aiming to shift the flow of money away from bad PACs, BICRA, as I said, raised the ceiling on individual contributions to candidate campaigns. There's some evidence provided by my future colleague, Adam Bonica, some evidence that suggests that individual donors are located more at the poles of the political spectrum. PACs are more centrist. This was a theme in Representative Cooper's lecture, which I had the pleasure of spending some editorial time with just yesterday. We're publishing it in Boston Review. Anyway, PACs are more centrist. So arguably then, the increased ceiling on individual contributions has fostered partisan polarization. So another day, another unhappy, unintended consequence issuing from a well-intentioned exercise of political power. And I'll come back to some related and arguably more serious worries later. Finally, limited government minimalism attaches large importance to unregulated political speech. It's deeply suspicious of such regulation because informed judgment is essential if electoral competition is to work as an effective, thus liberty-protecting check on the threats imposed by political power, and because the regulators cannot be trusted. This conception of political speech, which flows naturally from the three previous ideas about politics, the competitive idea of politics, protection of liberty through elections, and mistrust of power, that conception is suggested in Citizens United, where we are told that, quote, speech is an essential mechanism of democracy, for it is the means to hold officials accountable to the people. In a republic where the people are sovereign, the ability of the citizenry to make informed judgments among candidates for office is essential. The right of citizens to inquire, to hear, to speak, and to use information to reach consensus is a precondition to enlightened self-government and a necessary means to protect it. Political speech, I emphasize, is understood principally as a source of information for voters in their capacity as judges of officials. Resisting paternalism, mistrustful of political power, the minimalist rejects efforts to reshape the market for political speech with an eye to protecting voters from misleading messages. Not from indifference to misleading messages. Instead, the absence of restriction is understood, given the background of mistrust, the third feature, as the surest guarantee of competing messages. And competing messages will provide more certain protection than any regulations aimed at achieving some desired balance of positions or veracity of messages. To be sure, disclosure requirements burden expression, prompting opposition to such requirements by some adherents to limited government minimalism who hear disclosure and see compelled expression. But minimalists more commonly understand disclosure as a permissible burden on expression because it adds to the information available to citizens in their capacity as auditors of political performance. The democratic rationale for protecting speech lies principally in its contribution to the informed judgments who are to hold officials accountable. The central aim is not to ensure opportunities for citizens to express their views on and deliberate about political questions, much less equal opportunities, but to provide information that enables them to hold officials accountable. Now, at the risk of overstating the fit of practice to theory, I think it's fair to say that limited government minimalism animated congressional and court opposition to BICRA. So, consider first the court's indifference to speaker identity. Individual, corporate, whatever. Doesn't matter. That's perfectly reasonable if you're thinking of political speech principally under its aspect as a source of information for voter/judges and of all agents as equally good and equally bad sources of information. Speaker identity matters if you're thinking of citizens as speakers. It matters then that corporations have no consciences, no beliefs, no feelings, no thoughts, no desires. But since the 1978 case of Bellotti that I mentioned earlier, one important strand of argument has been to focus on the interests of free speech argument has been to focus on the interests of auditors and third parties rather than principally on speaker interests. As they said the majority said in Bellotti, the Constitution often protects interests broader than those of the party seeking their vindication. Because the First Amendment protects citizen auditors, standing in judgment of officials, the corporate identity of the speaker doesn't matter. The protection, so to speak, is of speech, serving informed accountability, not of speakers. Second, the unwillingness to defer to legislative judgment flows naturally from suspicion about power, in particular from a focused suspicion of political power. As a general matter, the First Amendment, the court says, is premised on mistrust of governmental power. As applied to regulating campaign finance, the suspicion shapes the concern, powerfully expressed in Bellotti, reaffirmed in Citizens United, that regulating speakers is a barely disguised strategy for regulating content and viewpoint. Restrictions on corporate speakers, for example, is a strategy for diminishing what are, rightly or wrongly, assumed to be the characteristic views of such speakers. Speech restrictions based on the identity of the speaker, Bellotti says, are all too often simply a means to control content. Or, as Justice Kennedy, echoing this, asserts, the purpose and effect are to silence entities whose voices the government deems suspect. Moreover, there is the concern that regulating campaign finance is a device for consolidating insider positions by protecting those positions from challengers who need to raise lots of money to overcome the advantages of incumbents. Thus, Justice Scalia's observation in oral argument in Citizens United. He says, quoting, "Congress has a self-interest. I mean, we are suspicious of congressional action in the First Amendment area, precisely because we, at least I am, I doubt that one can expect the body of incumbents to draw election restrictions that do not favor incumbents." Now, is that excessively cynical of me? I don't think so. End of quote. Finally, the limited government minimalist finds no democratic purpose in BICRA's efforts to achieve equal opportunity for influence. Instead, limited government minimalism detects a smug paternalism gotten up as egalitarian conviction. And even for those who do find cynical excess in this hermeneutics of suspicion, and grant that the conviction may be sincere and non-paternalist, concerns remain about the likely effectiveness of efforts to reshape the speech market for good purposes and the dangers of trying. Last section, democracy. So BICRA, I said at the outset, was the product of 6 years of congressional efforts. Those efforts reflected public concern about the growing costs of elections and about how those costs were getting paid. Those concerns were expressed in sustained public attention, constitutionally informed public debate, considerable legislative fact-finding, and many efforts to find a sensible legislative solution. Moreover, the public debate, like the congressional debate and the legal constitutional debate, was in part a political, philosophical argument, a debate about the kind of democracy we are to have, about the roles and responsibilities of citizens, the place of deliberation in mass democracy, and the importance and substance of political equality. The congressional and legal debate crystallized that dispersed and long-standing public argument about democracy, an argument informed by the Constitution and the court's evolving interpretation of it from Buckley to Austin to McConnell. When the court decided Citizens United, it jumped into that debate and announced, in effect, that the Constitution enacts the democracy of limited government minimalism. I find that conception implausible and see no case that it belongs to the Constitution, none, at any rate, that does not depend on its independent plausibility as a conception of democracy. But limited government is a reasonable conception of democracy, I've said, which is why I have that and no in my opening answer. But not to pause over that indecisiveness, what's disturbing for democracy, and here's the but yes of that opening answer, what's disturbing is not that the court picked limited government minimalism rather than civic equality, but that the court chose to foreclose this discussion, as if to exclude from democratic politics, not from public reflection, but from democratic politics, a long-standing set of questions about democracy itself. Disturbing because it foreclosed a politics of principled disagreement. In taking that question out of political circulation, it deprived democracy of important substance. The substance of having a consequential argument, an argument with consequence between and among citizens who have not only competing interests, but conflicting views about justice, the common good, and democracy itself. That spectacle of Americans arguing over democracy that Sean Wilentz identifies as so fundamental to democracy in America in the period between Jefferson and Lincoln. To develop and clarify the point, I propose to consider two objections. And yes, I am almost done. I know that'll come as a disappointment to some of you, but not that many. The first objection is that I may seem to be adopting a form of what might be called political thicketism, to be embracing the Frankfurter Harlan view so forcefully expressed in the dissents in the one-person, one-vote reapportionment cases of the early 60s. The idea that political philosophy is political, not legal. Harlan offered several reasons for treating issues of apportionment as non-justiciable political questions. But in part, that conclusion was driven by an observation about the kinds of disagreements that were at issue. Serious, long-standing, reasonable disagreements about the proper bases of political representation. The Chief Justice, Earl Warren, who rejected Warren's view, nevertheless identified the point precisely. He said, "We are admonished by the dissent not to restrict the power of the states to impose differing views as to political philosophy on their citizens." So, am I siding with the dissent in the reapportionment revolution? Not exactly, and for two reasons of both process and substance. First, an animating concern in the reapportionment revolution was that it had become impossible to use normal politics to achieve reapportionment. Efforts to rebalance urban, suburban, and rural representation were simply blocked by existing patterns of apportionment and the absence of an initiative route in many states, a point forcefully argued by Ansala, Beher, and Snyder in their book, The End of Inequality. Let's assume that Harlan and Warren are right, that the battle was in part about political philosophy. By the early 1960s, it was simply impossible, an observation that Justice Clark made in his concurrence in the reapportionment decisions. It was impossible to have that fight politically because of the widespread lock-in of rural power. No comparable concern extends to the campaign finance area. Second, the one-person, one-vote rulings were driven by a mix of considerations. Arguably, one was the political philosophical assertion that equally weighted votes are the only acceptable form of representation in a democracy, well, barring special circumstances like the Senate, say. But two other premises led to the same conclusion: that some extreme forms of vote dilution were unacceptable, at odds with the animating purposes of the 19th, 23rd, and 24th Amendments, which all stood for the proposition that voting rights are important to ensuring a protection of interests. And second, that keeping judges out of the apportionment business in the future required a simple rule, like one person, one vote. To be sure, other considerations were also in play. Putting all this complexity conveniently aside, I think there's a good case for the reapportionment revolution that can be made consistent with the view that questions about our form of democracy belong in politics. A second objection is that I'm pretending to a neutrality between civic equality and limited government minimalism. Not that I'm neutral, but that the court should have been. A neutrality that my own argument betrays. In asserting that efforts to address questions about our form of democracy, help to give substance to democratic politics, am I not simply invoking the civic equality conception of democracy? No. Frank says yes, I say no. Let's put it to a vote. In a word, no. Nothing in my case for deference to a political process that is sustained over several years, that involves considerable public and congressional attention, as well as lots of hearings and fact-finding, that is attentive to constitutional concerns, and that invokes judgments about the kind of democracy we are to have. Nothing in it draws on the idea of equal opportunity for political influence, but that is arguably the most controversial element in the civic equality view, certainly the one that's drawn sharpest criticism and most persistent criticism. Still, limited government minimalism may resist the idea that there is a loss when the scope of political competition is reduced, so that issues about the form of democracy itself are excluded from the purview of citizens and their political judgments. But the limited government minimalist must acknowledge that his or her favored view of democracy reflects a contestable and long contested judgment of political theory and constitutional interpretation. Acknowledge that long-standing and reasonable disagreement about democracy and politics, and it's hard to make a case for treating the resolution of the question, what kind of democracy are we to have, as a legal matter, to locate its practical settlement in a court, especially when ordinary democratic process is more or less openly and persistently engaging and contesting that very issue. Ronald Dworkin has long and powerfully portrayed the Supreme Court as a forum of principle. I don't want to dispute Dworkin's depiction of the court, but I want to observe that democratic politics comprises a more capacious forum of principle, a forum where political philosophy meets power. When democratic politics goes well, and it sometimes does, it is itself a form of principle, a forum where Gramsci's and Rawls's non-expert philosophers express their judgments, including their judgments about what democracy permits and demands. Does that hopeful assertion reveal a want of sufficient cynicism? I don't think so. I prefer to think that it shares Lincoln's patient confidence in the ultimate justice of the people. But wherever it sits on a spectrum bounded by reasonable hope and wishful thinking, I do think we all should worry about accepting the idea that when it comes to the kind of democracy we will have, conscientious citizens and representatives are auditors and spectators, not the active authority. My colleague Josh Ober has summarized his work on Athenian democracy this way: no democracy without argument over democracy. And Willents, who I've quoted before, observes that the rise of American democracy from Jefferson's era to Lincoln's created exhilarating hopes and prospects, but also fierce conflicts and enormous challenges about what democracy can be and should be. And he adds, obviously, those conflicts and challenges persist. Democracy can find no refuge from those conflicts and challenges in a jurisprudence of hubris. Yes, it's true, parts of BICRA may have been unwise, as if a lack of complete legislative wisdom were something that even bears mention. But if you think that democracy is a good way of doing business, and if you acknowledge, as you should, the variety of conceptions of democracy that can command the convictions of reasonable citizens, and if you consider the sustained public engagement that issued in BICRA, then Citizens United should trouble you too. Thank you. Frank, yes.
When you overheard that yes.
Yeah. Oh.
That escaped my lips at that point. I wasn't. I was talking to myself.
Yeah.
I wasn't responding to your question about whether you had in some way or other illicitly put a civic equality conception in the hat and then pulled it out.
You were rooting me on. Yes.
Yes, the yes was meant to be, yes, that's the question that you have to come to.
Okay.
Right, that in some way or other is a question that is impending as the discourse proceeds, and that sooner or later you have to get to. So, just to say a little more, I think this is all fairly obvious. If we're going to be conducting a civic debate in which the question, maybe as between these two versions, civic equality and limited government minimalism, maybe with other possibilities on the table, is what is our, or what is the right, or what is the best, or what is the most fitting for us conception of democracy. We have, I suppose, a thought that discussion itself is to be conducted and concluded in a democratic manner. So that's the puzzle. That's the conundrum. So then, if the answer to that question is yes, we have to be thinking that somewhere more abstract, more fundamental than these two competing conceptions of democracy, there's still a regulative conception of democracy that's operating so that we can judge whether this debate is being conducted in a democratic manner. And what I meant to be doing was affirming yes, but then there is a question that impends, which is if we could get a grasp of what that conception is, it might bear some implications for the permissibility of government regulation of the political speech. The conception of democracy that regulates the debate between civic equality and limited government minimalism might itself contain some limitations on what the powers that be for the moment can do by regulating the conditions under which that debate is.
Right. So, as I mentioned to Frank before the talk, as I was writing this paper, I was partly animated by some concerns that came up in a paper that Frank wrote for a conference in St. Louis in 1995, which was on exactly this question. I'm saying that partly by way of acknowledging that influence and partly to buy myself some time to think about what I might say in answer to your question. And it's not going so well so far. The way I think about this is I don't have a theory. I have a case. And as a case, a kind of challenge. So the case says something like, look at what happened in the process leading up to the adoption of BICRA in 2002. And when I said the description of that had a kind of tendentious granularity, I meant what I said. I mean, I included in the description a bunch of features of what happened in that discussion that made it look like, I think it's accurate, but I think it made it look like a pretty decent democratic process if you don't have excessively elevated standards. The case is something like, look at what happened in that process. There's a lot of widespread concern in the public. There's mobilization of groups. There's a debate. The debate is not just a debate about interest. The debate is partly, as I said, a debate about how to interpret the Constitution. It's a debate that's informed by what's happened in Austin, which is 1990. It's informed by what's happening on what's perceived to be the evasion of the previously enacted rules, which have been upheld under that's about, whatever your favored view of democracy is, it's hard to say that there isn't, that isn't an acceptably democratic process. And I want to add one thing, which is a little bit different in my case description than is common in democratic proceduralist stories of political legitimacy, which is that this is a kind of popular constitutionalist twist on that, which is that the issue about the constitutionality and about how to interpret the Constitution was part of the discussion. It wasn't the sensibility, as then Senator Feingold said, was not, let's do what we want to do and kick the question of constitutionality upstairs. It was, so you have not only an open argument, lots of fact-finding, mobilization extended over a long period of time, but an argument in which issues of principle, conceptions of democracy, and invocations of the Constitution are an important part of the discussion. I think that characterization puts pressure on a view that says, nevertheless, we're going to take this question out of political circulation. So I agree with you that there are the theoretical questions that you put to me, but I'm describing to you how I think this represents a challenge without having answered the question of what interpretation of the First Amendment is implicit in the background theory about democracy that you have to have in order to recognize that process as having a kind of binding significance.
That's a very good answer.
Thank you. Thank you. Charles.
First, I want to say that your description of limited government minimalism was so eloquent and so generous and so complete that I couldn't understand why it hadn't convinced you. And as you went on, I felt like something, and I discovered all of a sudden that my wallet is gone. So I'm trying to reconstruct where it is that somebody reaches.
No, you mean you're in a crowded subway and you're having a conversation with a person who you think is a nice guy, and then you discover that your wallet is gone.
So I'm trying to see exactly when somebody reached into my pocket in that way, and I think.
There you go, Charles.
I think the surveillance camera has picked out the moment. It's here. You say limited government minimalism is just one view of democracy and free speech among several. And therefore, because we are committed to democracy and equality, the choice between limited government minimalism and these others should itself be the subject of democracy.
And that's where I think I caught you reaching into my pocket. Because it seems to me that the whole tradition of free speech adjudication, since the famous dissents in Gitlow, then all the way then on to obscenity, then to the rejection of Catherine McKinnon's views about pornography as being bad for women, then to the whole view child pornography only applies insofar as a child is used in the creation of it, and not when it's virtual child pornography. And of course, the rattling of the chains of Lochner, which you did mightily and loudly at the beginning, was exactly the chains that were rattled in the whole commercial speech debate. And it would seem to me, therefore, that it has been settled in our jurisprudence that the important thing is that we, the listeners, make up our own minds, and that it doesn't matter, A, what is said, and B, who says it, and I suppose C, how often and loudly they say it. That's limited, if you like, that's limited government minimalism. Now, I think that is settled. It's settled in our jurisprudence, and Austin and Bikra sought to unsettle it. The 13th chime of the clock on those, of course, was that somehow they said, of course, media corporations, that is to say, Rupert Murdoch, well, they're separate, they're out. Why? That is an example of the corruption which enters in, that's when the hand reaches into your pocket. Rupert Murdoch can do it, and so can anybody else. I don't understand why General Electric can't do it. Well, of course they can, because they own NBC. So I think what we have is a jurisprudence which says, no, liberty, at least liberty of the mind, takes precedence of everything that you've said about democracy. Liberty first, then democracy. Not democracy first, then liberty.
Yes and no. But yes, right. Yeah. It's a common theme in my. I don't suggest that you try that at home, but so I just want to make one observation first, and then I'll try to engage your question, which I think is great. I circulated this paper to a few people in advance of giving it, and the consistent reaction of people who don't believe limited government minimalism, as you more or less do, I had you in mind among others, their consistent reaction is that I'm presenting a caricature of limited government minimalism, which I thought was ridiculous. And this is a serious, I'm very pleased that you think that this is a fair statement of the view, indeed so fair a statement that the clock chimes 13 on the subway while I'm stealing your wallet. So I agree with you that if the free speech tradition from Gitlow through Whitney, through Hudnut, through New York Times and Sullivan, et cetera, if all of that commanded was only interpretable as an embodiment of limited government minimalism, then I would be compelled to agree with you, because I think that those are all, more or less fixed points that you want to hold in place. I just don't believe that that's true, and I think there are a couple of reasons why I don't think it's true. First, I think the limited government, at one point in your description of limited government minimalism, you emphasize something that I think is right, that for the limited government minimalist, the principal role of citizens is as auditors of the speech, auditors of speech that others are engaged in, and then judges of officials on the basis of that speech, and you keep those being judged, you keep their hands off the speech that's informing judge. But I think it's a fundamental feature of the civic equality view, which does resonate with some of the concerns that animated the one person, one vote decisions, that citizens are not simply auditors of the speech of others. They're speakers, they're agents, and in their role as speakers and agents and not just auditors, you want to ensure that they have fair opportunities to present messages. That's what I think regulation in this area is about. It's not about correcting misleading information in the speech market. It's not about establishing some notional balance of messages or avoiding people from being misled. It's about ensuring that people have opportunities, fair opportunities, I say equal opportunities, fair opportunities to be agents in democracy. And that, I think, is a fundamental difference. And I do believe, if you go back to the principle of political equality I stated, it has these three components. The first one is a kind of free political speech with very strong condemnation of content and viewpoint restriction. And I do think that that's a fixed point. That is something that's shared by both views, but I don't think that requires either two things that I think of as distinctive of limited government minimalism. One is casting of citizens in the role of auditors rather than agents, and secondly, the kind of pervasive mistrust of the exercise of political power, which leads limited government minimalists to always be at the after party. Whenever anything good happens from the exercise of political power, like the Civil Rights Revolution or the revolution establishing greater equality for women, or the establishment of some kind of basic social welfare protections, limited government minimalists always celebrate them after the fact, but they're always among the people who are suspicious before the fact, suspicious because they recognize that each of those requires an affirmative exercise of political power. But let me just, I want to come back full circle and just emphasize that I'll take the question as a challenge. The challenge is that if you can't accommodate those fixed points in the free speech tradition within the civic equality view, then there is a case that limited government minimalism is the story about democracy and the Constitution. I just don't believe that. Yeah. Yes?
You made a very insightful argument that the problem with the court in Citizens United was that it imposed a particular conception of democracy, what we call limited government minimalism. I wanted to ask you, and you said that instead of the court ruling about the proper conception of democracy, that we should defer to what the public decides. I wanted to ask two questions about that. The first is, how can the result of democratic deliberation about the proper democratic theory be legitimate unless equality and participation is guaranteed? So if corporations can participate much more than ordinary citizens, then you think that the decision that's reached by democratic deliberation in the general public might be biased or unfair one, or even undemocratic one. And the second question is, you said that the court should be neutral with respect to the proper democratic theory, but my opinion point is, how can the court be neutral when it comes to democratic theory? Do you think that the court would have to endorse one democratic theory or another in order to interpret democratic concepts such as one person, one vote, or in order to make decisions when it comes to such as the Citizens United decision, where democratic concepts are explained?
So this is, I think, in some substantial measure, a replay of Frank's earlier question. And if I had a better sense of what since I answered that one to Frank's satisfaction, there's something that I left unanswered. So let me say a couple of things. First of all, as I said in the comments on the reapportionment revolution, and in making those comments, I was largely echoing the discussion of the reapportionment revolution that you get in Ely's Democracy and Distrust, where he's trying to make the case that, so in the reapportionment cases, there are ringing endorsements of the proposition that one person, one vote is more or less what democracy means. Declaration of Independence, and question is done. I don't find those particularly persuasive. I do think that there's another line of argument, and I think those are fairly I do think that those are fairly criticized by the political thicketism views of Harlan and Frankfurter, but I do think that there's another line of argument of the kind that I mentioned that has the two features that I mentioned. That is that there is an endorsement in the 19th, 23rd, 24th Amendments of the importance of the right to vote as a way of protecting interests, so that there's some kinds of effective influence dilution that are unacceptable, and then you want some kind of simple rule. And if you put those two things together, you can get a one person, one vote rationale without invoking the conception that was invoked in different ways in the reapportionment decisions, that this is, that's a one-line argument that, we've got a democracy, one person, one vote, so what are we talking about here? So I tried to offer a different line of argument about that. But also, I'll just go back to what I said to Frank. What I want to ask is, if you look at what happened in the run-up to the passage of Bikra, which included a bunch of familiar features of democratic process, plus, this is the thing I emphasize, plus an argument about democracy. That's there on the table. There is a political philosophical argument about democracy that's on the table. And that's part of what happens. Look at the debates on March 20th, 2002. A lot of words, but that's what's happening there. And so so we have a choice. Maybe I should put it back as a question. We have a choice. There's a decision that's made. And no one, not one single person in those debates on March 20th, 2002 questions the legitimacy of the process that's leading up to the final debate. None of them says this is not really a democratic process because it's violent. They think it's a democratic process. They're arguing about this. They're arguing about the nature of democracy, about the Constitution. And then they make a decision. Okay, now somebody else makes a decision. They make a different decision. Part of the decision that's made on March 22 is about what the Constitution says. I'm having trouble seeing why, in the face of a process of that kind, there's a need to defer to the decision of the court, and I'm having trouble seeing why you have to think of the court as the ultimate arbiter of what democracy is, other than in Frank's sense of there's some background idea that the court is the ultimate arbiter of what democracy is in order to decide that that procedure was good enough. Yeah. Larry.
So I wonder, I don't like feeling like I'm going to be the ACLU here for a second, but I'm going to be the ACLU for a second. I wonder how much other First Amendment doctrine unravels if we take seriously what you said. I mean, because there are a lot of particular moments in state or federal history when there's a debate about some regulation which eventually is held to be violative of the First Amendment, where the debate is just like the Bikra debate. Long debate, people take it seriously, the law, and the court comes down on one side or the other on it, and Josh Cohen-like person can come along and say, hey, what you disagree about is really political philosophy here, you gotta leave this kind of thing open. So for example, all the debate about whether we can ban a communist party or ban communist speech or ban hate speech invokes conceptions of democracy inconsistent with the German democratic, militant democratic conception of democracy. And we have there's a substantial debate in this process about which is really a good one lean down firmly on one side, shut that other side off. So if we followed your method here, would we need to reopen a whole line of these types of questions in those other cases to be remain open or not agnostic about this underlying conception of democracy?
I'm going to take what I don't think so, but I'm going to take a somewhat cheap way out in answering the question, because it's in some ways it parallels what Charles was asking about. I mean, I don't think that if you take the two conceptions that I described, limited government minimalism and the civic equality view, where it's just built in. I mean, you might say, why is that built in? Isn't that just convenient? But it's built into the first element of the civic equality conception of political equality, that there's a strong pushback against content and viewpoint regulation. So as between those two views, it's a sort of, it's not part of the discussion between those views about whether content and viewpoint regulations of a kind that you have with regulation of communist speech, for example, that's not a point of controversy between them. So I mean, it's a cheap answer to the question in that maybe there's a wider spectrum of, reasonable views about democracy, and that issue is unsettled between them. But at least for I'm inclined to think not, but at least for the views that that have been the focus here, I don't think that's an open question. As I say, it's perfectly fair to say, but either that there are other conceptions or that the civic that so I'm treating, I should just say this, there is a view that my sometimes colleague, your former colleague, Kathleen Sullivan, who does take the ACLs, has taken on these issues, where she says that the implicit political philosophy of the court, of the dissent in Citizens United, is a view about free speech as essentially an anti-discrimination principle. If people had only understood everything that you could do with the equal protection idea, they wouldn't have bothered to write the First Amendment, which is a view that people have taken on the religion clauses as well. It's the view of the Eisgruber and Sager book on the religion clauses. And I just don't share that view at all. And the reason at one point in the paper, I said that I was trying to present the civic equality view in some detail, partly as a pushback against what I regard as caricature. I was not thinking of the caricature by limited government minimalists. I was thinking of the caricature of Kathleen in particular, who thinks that it's just about anti-discrimination. I think there is a strong affirmative idea about the importance of speech. Contributions goes back to the thing with Charles before about listening versus group. That's part of the civic equality view. Anyway, I have to come over to this side. Jenny. Yeah.
By stressing the citizen as speaker over the citizen as auditor, aren't you giving away half the argument for Citizens United? I think Professor Freed's point, where he says it doesn't matter how often or loudly they say it, and that may well be settled jurisprudence. I don't think that's very good deliberative democratic theory. That is to say, I think that if the citizen as auditor only hears one side, or hears because somebody's saying it very loud and very often, the citizen as auditor is being cheated. So I think that you're giving, by throwing the citizen as auditor out, you're giving away one of the strongest arguments for citizen.
I mean, my first defense about giving away half is that that's smaller than 2/3. So, but more seriously, I think there are 2 points that I want to make, 2 related points. The first, just straightforwardly, is that I don't mean at all to be giving away the importance of citizen as auditor. It's an element of the civic equality view. It's when I initially described it, the fourth element of this is connected to. But and here, I mean, I think Charles and I may be in substantial agreement. I don't think, excuse me, once you've said that you want the auditors to be hearing, you know, many sides, a well-conducted conversation, there are two things that might give you pause, acknowledging that that's a good thing. One is that there is something arguably fugitive about the idea of, you know, the well-conducted conversation, and the fugitiveness of the idea may provoke concern about monkeying around with something that you don't want to be monkeying around with. The other is, even if you think that you've got a pretty good idea about a well-conducted conversation, this contest that's hearing different viewpoints, you have two choices. One is, you have two choices. One is to say, well, make sure that you have the regulator diminish some voices, and the other is you think the regulator starts trying to diminish voices, that's going to cause troubles. The way that people are going to hear these different views is because when people have something to say and they want to, you know, they feel a sense of urgency about it, they say it and they push back. And you don't need that kind of solicitude in order to hear the kind of solicitude that you're suggesting you need in order to get the range of voices. The other thing is, and this goes to an issue that I didn't talk about at all in this paper, which is if you think that and you're prepared to do something, those are reasons for floors, not ceilings, for subsidies, not regulations. I mean, that's a reason for, that's arguably a reason for having a system of public finance. It's not a reason for imposing greater burdens on, as BICRA did, for imposing greater burdens than previously existed on corporate and union speakers. I think those really do have something to do with the importance of equality of speakers and not just a solicitude for auditors. I want to just add this one, something that I said at the end there. I want to emphasize this. It's a very important point in the dissent in Citizens United. It's absolutely correct, and it's important to keep it in mind. The status quo before the Citizens United decision was that if you were a company and you wanted to spend a bunch of money on an election, what you had to do, it wasn't that you couldn't do it, what you had to do was set up a segregated fund and get people to voluntarily contribute to the segregated fund. So everything that could be said after could also have been said. There was an additional burden, but this was, it's not that there was, what happened was that something that could already be done was made a lot easier. This isn't exactly on your question, but I just want to emphasize it. There was something that people could already do that the Citizens United decision made a lot easier. It's not like the Citizens United decision said for the first time that it's okay for, you know, companies to be engaged in independent expenditures. You just had to do it in this other more circuitous route before. Anyway, yes.
Nolan Bowie, can I just go quick on that? If the core democratic goal of First Amendment is to enhance equality of opportunity to influence political opinion or civic equality, as you said, shouldn't government regulate broadcasting as a common carrier, which would level the playing field? It promotes non-discrimination, first come, first served, no censorship, and it would undermine the negative consequences of money and citizen
Yeah. So two things. First, I don't think that let's start by putting the question back 20 years. I think that for the civic equality view, the civic people who hold the civic equality view were then, me included, were sympathetic to those kinds of regulations. I just think that the reason I say putting it back 20 years is when you fast forward to the present, given the differences in the media market. Yeah.
Present regulation of broadcast is based on a theory that the spectrum is scarce. Spectrum is scarce especially. We have an abundance of channels and boards.
Right.
And most money now to influence elections is spent on access to broadcast audiences, primarily television. Why is this so? It's not democratic.
I think I agree that, as I was saying, that the civic equality view is friendly to regulation in this area, and I don't think that I think that there should be an openness to accepting regulation in this area. I just don't. So I'm not sure. You seem to be puzzled by that.
I think that regulation is more minimal than.
Right. So you're right, and I think that I think putting aside everything that's happened in media markets for the past 20 years, where they have been substantially transformed by the existence of the internet, by the existence of social media. So they've been substantially transformed. Putting all of that aside, I think I'm sympathetic. Sympathetic to that. I don't think that that's the status quo on regulation. That's because I don't think the status quo on regulation embodies the civic equality view. I think the status quo on regulation is, to that extent, because I endorse the civic equality view, I think the status quo on regulation, again, abstracting from a whole bunch of questions about the transformation in media markets, I think the status quo on regulation is not what a civic equality Democrat endorses. Now, if you say to me it's undemocratic, I say, yeah, I agree with you about that. That's because I endorse the civic equality view. Do I think that there is therefore an affirmative obligation that ought to be enforced at court order to reallocate the spectrum? No. And that's just a direct consequence of the view that I advance in the paper, which is that there is a debate about democracy. I think I take seriously what I said in the debate. There's a debate about democracy. I think that the current, the status quo about media regulation, about spectrum allocation is legitimate. I think it's democratically legitimate, although I think it is not what a civic equality Democrat supports. But I also do think that any discussion in this area has to take pretty seriously and the transformation in the terms of mass communication that have occurred in the past 20 years, and particularly in national politics, really, really in the last 5. One last question. Norm?
Just trying to understand the force of what you're arguing, and it's
turn your microphone on, please.
Sorry. Trying to understand the force of what you're arguing, Josh, and partly goes back to Charles Fried's question as well. So one way to take your argument would be to say there's an ongoing debate about democracy. It shouldn't have been squelched by this court ruling. A further claim would be it wasn't squelched by the Constitution. That we should interpret the Constitution as being open to both of these ideas about democracy, and that's an ongoing issue about how to resolve it. And I take you to have been arguing the latter, which means you have to be able to reconstruct the previous freedom of expression cases in a particular way. Is that the...
I think that's a fair, I do mean to be saying, among other things, the latter, yes. So as I said at one point, only in passing in the paper, and I'll say why only in passing, I don't think that what I said, something like, I'm sorry, I'm obnoxiously quoting myself, but whatever. What am I supposed to quote you? I mean, you asked me, so I'm quoting myself. So what I said was something like that I didn't think that there was a compelling case that one of these views belonged to the Constitution, particularly not a case that you could make compelling independent of argument in political philosophy. So I don't think that, so if someone says, and this is, a way of construing, as you say, a way of construing what Charles was saying, which is, you say this, and somebody says, and Justice Kennedy, as it might be, says, look, I'm just doing my job. My job is to say what the Constitution says. The Constitution says enact limited government minimalism or whatever. And I don't believe, Justice Kennedy, don't believe that the claim that it enacts limited government minimalism, so it does, depends on any further judgment in political philosophy about what the correct conception of democracy is. Well, if you say, it's fine to say that. I mean, frankly, I don't believe it for a second, not even for half a second or 2/3. And part of the force of the part of the paper about the Breyer and Scalia is to say that invocations of the democracy that's ingredient in the Constitution are pretty common, and there is this striking fact that the two people who stand sort of more or less at poles of the current court both invoke this at 30,000 feet as the fundament, as a theme, as Justice Breyer says. It's a theme. One theme in the interpretation of the Constitution, and then they take it in these very different directions. It's because I think that shows more that questions about what kind of democracy the Constitution enacts are, sort of open. Now, of course, you could say, as Justice Scalia would say, of course, some bozo like Justice Breyer, he invokes this other conception of democracy. That doesn't show that there's an open question about what conception of democracy the Constitution enacts. It enacts limited government minimalism, and I find that has all the advantage of rhetorical theft over honest argumentative toil. I just don't. It seems wildly implausible to me to say that. But I think the focused challenge is the one that Charles raised before. I mean, you need to be able. Certainly, I need to be able, given what I say about the principle of political equality, that's part of civic equality, which tries to incorporate the free speech tradition. You have to be able to say that that line of cases and principles can be reconstructed in this civic equality way, and I think it can be. Yes.